Well, it's been quite a day today from the election results in the Northeast to a landmark judgment in the Supreme Court, with the Supreme Court stating that election commissioners will be appointed by a panel which includes the Prime Minister, the Leader of the Opposition and the Chief Justice of India. It's being seen as a landmark verdict which is aimed at maintaining the purity of elections. But if you actually look at what the judges have actually said, it is an effort, one would suggest, at ensuring that our democracy, what we hold dearest, is protected at any cost. Joining us now, a very special guest, the senior Supreme Court lawyer, Mukul Rohatgi. Thanks, Mr. Rohatgi, very much for being with us. I think let's look at some of the key points mentioned and key quotes from the judgment itself. The first one: a party in power will have an insatiable quest to remain in power through a servile commission. Is it your view, sir, that the Election Commission, as it presently stands, is servile in context of its equation with the government?
I think it is an unfair comment. The Election Commission is one of our most impartial bodies from the times of late TN session, and I think in the last 60, 70 years, it has acquitted itself admirably. Therefore, I do not see any basis for a comment of that nature, at least for this body.
Mr. Rohatgi, another quote.
Insofar as, yes.
Please go ahead, sir. Finish your point.
Go ahead.
Another point. The unrelenting abuse of the electoral process over a period of time is the surest way to the grave of democracy. The Supreme Court, very concerned about the potential abuse of the electoral process, hence their judgment today. So, again, concerns about the Election Commission.
Now tell me, Vishnu, this country is the largest democracy. Elections are an ongoing process in this country, from municipality to legislative assemblies to central elections to parliamentary elections, and today itself results have been announced in several states. I do not think that there has been a case in the last maybe about 20 odd years where the elections have been called as manipulated by anybody, including the losing party. The issues of booth capturing and so on are now a relic of the past, and our election machinery is so good and swift that results come, you see, from 8 o'clock in the morning. There is never a hold-up, there is never a vacuum. And surprisingly, if you remember, in the US, for the presidential election a couple of years ago, there was a big faux pas, and it was held up, you see, for a while.
Because of hanging chads, I remember that.
That's right. So there should not be any misconception that our body is not up to the mark. Holding elections for 100 crore people is an admirable thing, and I don't think that there is any basis to doubt today or in future. Unless that situation is reached, there is no reason why the final verdict should have been what it is, and I want to make a comment on that, but after your question.
So I would disagree with you with 4 specific examples of when the Election Commission has been called into question marks about them. 2018, the opposition alleged the Election Commission delayed poll dates for states because of a rally of the Prime Minister. November 2022, questions over the hurried appointment of Arun Goel as Election Commissioner, who was appointed by the government within 24 hours of voluntary retirement. Number 3, January 2023, opposition parties questioned the Election Commission on the need for remote voting machines. And one final point, February 2023, what's happening now, the different factions of the Shiv Sena, the EC allotting the Sena name and symbol to the Shinde camp. Now, it's a legal issue, but this is when the EC the question marks on the EC have been raised. Hence, the Supreme Court, one would argue, has said that there needs to be more steps to ensure its independence.
Now, Vishnu, you have picked out 3 or 4 instances in the last 50 years. Now, let me tell you every time the election commission decides, the losing... Can you hear me?
Yes, sir, I can. Go right ahead.
The losing party always blames the election commission. In fact, if you talk about court cases, every day the losing party blames the judge. Whichever the judge is, whichever court, it's a natural instinct. Whether it's a Shinde matter or any other matter, people blame the speaker, people blame the election commission or the decision-making body. That cannot be a ground at all to question the impartiality. I can tell you, some years ago, I did the symbol issue of AIDMK, etc. 4-5 years ago. That hearing was done by the EC. The losing party challenged the decision of the EC in the Delhi High Court and the Supreme Court by saying it is partisan and they have prejudged the issue. I mean, that cannot be a ground. Now let me talk about Goel. You have mentioned about a particular incident. Now if Goel's appointment seems hurried and does not seem to be appropriate, see, one flash in the pan cannot result in a situation where you proceed and supplant the law. Now let's go to the law. Article 324, which was made in 1950 by the constitution makers, clearly said, subject to a law to be made by Parliament in future, the President of India shall appoint these persons. The President of India under the Constitution means the central government. Therefore, the President does not act in his own discretion.
Right.
He acts on the aid and advice of the government. Now, this has happened in the last 60-70 years. Now, if at all, firstly, it is within the province of Parliament. If Parliament does not do, the Constitution makers said that the President of the government shall do. Now, let us assume in your favor or in favor of the opposition saying that sometimes you like to fill up people, etc. Now, that cannot mean that the remedy is worse than the disease. The court could have said that let the government frame a transparent policy
Yes.
for appointment rather than saying that we, as the court, we now direct a committee to be formed which will consist of the Prime Minister, the LOP and the CJI. We form a committee and we give them the power to appoint these persons. I think that is a judicial overreach because such a committee is in contemplation. If you look at the Lokpal Act, Lokpal has to be appointed by such a committee, but yes.
Sir, I'll give you one more example, and this is, you've spoken about how opposition parties can be complaining about an election result, etc., or a particular decision. But what if the election commission within itself starts complaining? 2019, the election commissioner Ashok Lavasa demanded dissent notes within the election commission on code violations be made public. The poll panel refused to make these dissent notes public. Lavasa recused himself from these violations cases.
So my friend, my answer is very simple. That the court can act. Let there not be a vacuum. The court should have, in an appropriate manner, directed the government to frame a transparent policy as to how they will appoint, from where they will take people, how people will apply, how they will decide. Let there be a transparency. But that cannot be, you see, substituted by a body to be named by a court to do a particular act which is not provided in any law, much less the Constitution. I think it's a case of an overreach which was not warranted by the facts, and I don't want to repeat, but it is clear to me that this is one body which cannot be looked at in a tarnished form like many other bodies in this country.
Mr. Rohatgi, I'm just looking at the order, and towards the end, there is a statement which says, this norm, in other words, the Prime Minister, LOP and CJI panel will continue to hold good till a law is made by Parliament. Is there a way out of this?
Right. Well, that's what I'm saying. The court should not have created a panel by naming the functionaries who will man it, because ultimately it's law to be made by Parliament. But then, till then, as a stopgap measure, as was done in the Vishakha case relating to sexual violence in domestic places, etc., the court could have asked the government to make a transparent set of rules, and that should have sufficed till a formal law is made by Parliament. But creating a body, creating members of that body, I think is beyond the remit of the court. The often spoken system of separation of powers, according to me, has been blurred, and this might be suspect, is what I feel.
Mr. Rohatgi, one or two more points. Again, a quote from the judgment. A person who is in a state of obligation or is indebted to who appointed him fails the nation and can have no place in the process of election, which forms the very foundation of democracy. Sir, this is, some would suggest, a judgment which protects our democracy in as much as it protects the operation of the Election Commission. Is this not common sense, sir? If I, as an officer of the Election Commission, am appointed by the government offers or gives the funding to my institution and pays my salary, picks me on the basis of my professional competence, or for whatever reason I am indebted to that government. That this is what the Supreme Court wants to try and avoid.
Well, I would say that you have to expect people to rise to the occasion. When you expect constitutional functionaries, they may be ordinary mortals, but you expect them to rise to the occasion and not be partisan as to which government appointed which person. Now, if you take this principle forward, why would not this principle apply to every member of the tribunal? There are hundreds of tribunals in this country. You have income tax tribunal, you have sales tax tribunal, you have GST tribunal, you have appellate electricity tribunal, you have TD SAT, you have IBC tribunal. If everybody starts feeling that I am beholden to the government who has appointed me, I mean, you can extend this principle to absurd limits. You can go to this, you could go to appointees of constitutional courts as to who is appointed whom. I mean, if that is what is to be looked at with suspicion, I am sorry, sir, the system of democracy and constitutional functionaries and what they are expected to do will completely fail.
Sir, one final question, and again, the context of what the Supreme Court has done is partly to do with what we see in our country. One of the points mentioned, for example, a large section of the media has abdicated its role and has become partisan. The means to gain power in a democracy must remain pure and abide by Constitution and the laws. Elsewhere, and I can't find it over here, the Supreme Court has stated its concern about money power and elections, and how the Election Commission needs to have been able to have sorted that out. These are concerns which have been stated, sir, and these are facts.
Well, I can only say that issues of media, whether media is partisan or media is running amok or media is wild and there is no proper regulator, is a completely different issue. It has nothing to do with the appointment to a high-powered post of the Central Election Commission, just as it is for constitutional courts.
Mr. Rohatgi, one or two more questions. There's been another very important direction by the Supreme Court today as far as the allegations against the Adani Group are concerned. The Supreme Court has appointed a panel to actually look into the allegations which have made. This comes at a time when several political parties have been asking for a JPC. Do you believe that the panel appointed by the Supreme Court is the way to get to the bottom of this?
I think it is appropriate in the facts of this case, not because of Mr. Adani, but because there are millions of share and bond holders in this country who back particular big businesses. If they have suffered, I think the court's concern is quite justified, and rather than having a JPC and making it a political slugfest, idea is to look at what the problems of the system are and plug the loopholes so that shouldn't happen in future that either a foreign report comes and shakes the market and reduces the to a great extent the investment of people, their return of lakhs of crores, and also that people in this country do not change valuation of their shares because of their manipulations, etc. I think it's the right thing. It will instill confidence in the market and in the people who are in the market. And I have gone through the names which the Supreme Court has chosen, and I think the names are excellent. They are people from different sections of the society, including lawyers, and I think that probably is appropriate in the facts of this case. It will be rather swift and it will help in this kind of problem rather than having a JPC, which will become again a slugfest. That should be avoided, and I am in agreement with what has been done.
Let's look at the names, sir, for a moment. Justice Sapre, he heads the committee, a former judge of the Supreme Court of India, O.P. Bhatt, former chairperson of the State Bank of India. The State Bank of India is important because questions have been raised on Adani's exposure, etc. Justice Devdhar is another one. He practiced in the Bombay High Court earlier on. He's a constitutional expert. He's practiced constitutional law, cooperative society, service law, etc., customs law. K.V. Kamath needs no introduction. He served as chairperson of Infosys, non-executive chairperson of ICICI. Nandan Nilekani, co-founder of Infosys, somebody associated with the Unique Identification Authority of India. Somsekhar Sundaresan, right, the well-known corporate lawyer. The point I raise these names is because some would argue that these are among the most credible faces in India to be dealing with this set of accusations. So therefore, the selection of names, very important. You believe it's been rightly done?
I think the selection is par excellence. All these names have high credibility. Two of them are retired judges. I have appeared before them on a number of occasions. I have found that they have always been upright. And Mr. Somsekhar, I know for a number of years, he knows the share market and the SEBI laws very well. And as you said, Nilekani is a pioneer and so is Kamath. Then where is the question? And Mr. Bhatt, I personally don't know, but he has been chairman of SBI, high post, high ranking post for all these people. So I think the selection is appropriate and cannot be faulted.
A final question on the remit of the committee, because I think this is important also. People who want more details, the facts to come out as far as these allegations are concerned, would want to know what this panel is actually looking at. So, very briefly, to provide an overall assessment of the situation, including causal factors, to suggest measures to strengthen investor awareness, to investigate whether there's been a regulatory failure, and to suggest measures to strengthen statutory and regulatory frameworks and secure compliance with the existing framework for the protection of investors. It's this focus on investors over and over that the common person must be protected, which seems to be the primary direction which the Supreme Court has taken in asking for this panel.
See, I have not gone into the details of the order, but from whatever little I have seen, it seems to me that the remit of the committee is wide and sweeping, and that is why a high credible panel has been chosen, and it is my sincere wish and desire that they go into all the issues raised by that report and then see whether there is a systemic failure or whether some share prices have been pumped up by a particular body, by a particular company, etc., and then come out with a set of suggestions. So it should not happen in the past that it should not happen in the future, that if I have invested 100 rupees and suddenly like a flash from the skies, that like lightning falling from the skies, my 100 rupees become 50 rupees. That will be disastrous. So we must have maturity in the markets, and I think the court has taken the right step, and I hope this committee will give an appropriate report at the earliest.
All right, Mr. Rohatgi, it's been quite a day, hasn't it? Northeast election results, election commission, this panel which has been formed to look into these allegations. Thank you so much. Wonderful as always to speak to you. Thank you very much indeed, sir.
Thank you very much. Good night.